My name is Andrew Lee. I'm an attorney at Swerdloff Law Firm. One of the services that we provide at Swerdloff Law Firm is the creation of wills and trusts. In California, if you choose to proceed only with the will, or if you fail to create any will or trust, your estate, if it exceeds $150,000, will be subject to probate. One of the main differences between a will and a trust is that a trust is more comprehensive and will allow you to avoid probate court. Probate court is often a lengthy and expensive process where you have to go to court and the judge will question whether you really intended to distribute your assets in the way that you wrote in the will. With a trust, you'll be able to sidestep that entire process. Well, one of the major differences between a will and a trust is that a will is more of a statement of intent of how you would like your assets to be distributed upon death. A trust has the power of law behind it to enforce your intent. So there's less room for the judge and the probate court to question whether you truly intended to distribute your assets in the way that is written in the instrument. One of the unique offerings for our clients here at Swerdloff Law Firm is a package with the trust, with the revocable living trust, which includes a pour-over will along with powers of attorney and healthcare directives. So a pour-over will, spelled P-O-U-R over O-V-E-R, will. Pour-over will is a document that enables the trust maker to state their intent about how they'd like their assets to be handled for assets that they have not included in their trust. For example, any personal property that may have been acquired after the trust was created and the trust was not amended to reflect that this personal property is included in the trust, they have the pour-over will, which can be used to state their intent to distribute that asset upon death. You, the client, have the right to decide how you'd like to die. If you would like the doctors to try every effort to prolong your life, then you have the choice you have the ability to make that choice with the living will. On the other hand, if you would like to end your life with a minimum of medical intrusions, with palliative care on your own accord, then you can choose to do so with the living will.